A smile is the universal welcome. If your actions can inspire others to dream, learn, and to become more, you are a leader. We will all agree that our MMBA president, indeed one of the best leader. Now I request Mr. S. Srinivasaragavan, the president of MMBA, to deliver the welcome address.
Happy evening to one and all. This evening is a special evening. This occasion is a special occasion. First time, a farmer rose to a great post. He has become a special government pleader. He has become the judge of this Chartered High Court. He has become a very few judges who have been elevated to Supreme Court without becoming a Chief Justice of any state High Court, and who has become the first Chief Justice of India from the state of Tamil Nadu. And what I mean by Tamil Nadu is accepting the states of Andhra Pradesh, Karnataka and other states which form part of Madras Rajdhani or Presidency. Now, after demitting his office, he has assumed the gubernatorial role in Kerala, and now he is a happy farmer. A farmer judge is now a happy farmer. So we are proud to have Honorable Mr. Justice P. SATHASIVAM, former CJ of India, as a chief guest here. Let us all give him a warm welcome. We are very happy to have Mrs. Saraswati SATHASIVAM, who has come here to grace the occasion. Madam, you are welcome. We are proud to have Honorable Mr. Justice R. Vijaykumar, Honorable Justice Mr. K.K. Ramakrishnan, amidst their tight schedule, being the guest of honor here. Welcome, sir. And I wholeheartedly welcome senior advocates, Mr. T.S.R. Venkatramana, Mr. S. Meenakshandaram, and Mrs. Krishnaveni, who are going to offer their addresses here. And I welcome all the advocates, especially President and Secretaries of the Friendly Brotherly Bar Association. And I'm extremely happy to welcome Honorable Mr. Justice S.S. Sundar, Administrator of Madurai Bench of Madras High Court, for being present here to offer his felicitation. Once again, I welcome one and all for this momentous evening. Thank you very much.
Thank you, sir, for the welcome address.
May I now request the President of MMBA, Mr. S. Srinivasaragavan, to kindly present the memento to our chief guest of this pleasant evening, Honorable Mr. Justice P. SATHASIVAM, former Chief Justice of India, as a token of love. Thank you, sir, and thank you, Lordships.
May I now request the General Secretary of MMBA, Mr. Airam K. Selvakumar, to kindly present our chief guest, Honorable Mr. Justice P. SATHASIVAM, former CJ of India, with a gift. Thank you, sir. Thank you, Lordship.
May I now request the Librarian of MMBA, Mr. K. Prabhu, to kindly present the memento to the Administrative Judge of this Honorable Madurai Bench of Madras High Court, Honorable Mr. Justice S.S. Sundar, as a token of love. Thank you, sir, and thank you, Lordships.
May I now request the Treasurer of MMBA, Advocate P. Sarvanakumar, to kindly adorn the Administrative Judge of Honorable Madurai Bench of Madras High Court, Honorable Mr. Justice S.S. Sundar, with shawl. Thank you, sir. Thank you, Lordship. May I now request Senior Advocate Mrs. N. Krishnaveni to honor Mrs. Saraswati SATHASIVAM with a shawl. Thank you, Madam. May I now request Senior Advocate Mrs. N. Krishnaveni, former President of MMBA, to felicitate our Chief Guest, Honorable Mr. Justice P. Sathasivam, former CJ of India, with a few words.
Vanakkam. Honorable Mr. Justice P. Sathasivam, former Chief Justice of India and former Governor of State of Kerala. Honorable Mr. Justice S.S. Sundar, Administrative Judge of Madurai Bench of Madras High Court. Honorable Mr. Justice R. Vijay Kumar, Honorable Justice Mr. K.K. Ramakrishnan, President and Secretary of and other office bearers of MMBA, President and Secretaries of other association, Senior Advocates, Mrs. Saraswati Sadasivam, my dear young and energetic advocates, good evening to one and all present here. I am honored and privileged to be here for the felicitation of Honorable Mr. Justice P. Sathasivam, former Chief Justice of India and former Governor of State of Kerala. Honorable Judge enrolled as an advocate on 25th July 1973 at Madras. His Lordship was then appointed to the post of Additional Government Pleader and later as Special Government Pleader in Madras High Court. His Lordship was appointed as a permanent judge of the Madras High Court on 8 January 1996 and was then transferred to Punjab and Haryana High Court on 20th April 2007. His Lordship was elevated to the post of Judge of Supreme Court of India on 21st August 2007. Honorable Judge has authored several path-breaking judgments, including the Reliance Gas judgment in May 2010, where His Lordship observed that in a national democracy like ours, the national assets belong to the people, and the government owns such assets for the purposes of developing them in the interest of the people. His Lordship also delivered verdict in the triple murder case of Graham Staines and commuted the death sentence of Dara Singh to life imprisonment. On 19th April 2010, His Lordship delivered the judgment in Jessica Lal murder case. Along with Honorable Justice B.S. Chauhan, Justice Sathasivam delivered the judgment in 1993 Mumbai blast case, sentencing Hindi cinema actor Sanjay Dutt to 5 years of imprisonment under the Arms Act, and that was also asked to serve out the remainder of his sentence. His Lordship's respect towards women and children and concern towards the issues faced by them is reflected in various judgments of His Lordships, where the Honorable Judges cautioned the courts against awarding lesser sentence in crime against women and children and showing undue sympathy towards the accused by altering the sentence to the extent of period already undergone. In January 2014, a 3-judge panel headed by Chief Justice Sathasivam commuted the sentences of 15 death row convicts, ruling that the inordinate and inexplicable delay is a ground for commuting death penalty to life sentence. His Lordship adorned the post of Chief Justice of India from 19th July 2013 to April 2014 and served as Governor of Kerala from 5th September 2014 to 6th September 2019. I have had the privilege to witness His Lordship practice at Madras High Court when I entered the bar. When His Lordship was a judge of this High Court, I am sure that many of them present here would have witnessed how courteous and justice-oriented His Lordship was. His Lordship hails from an agricultural family in Erode district and is the first-generation lawyer of their family. His Lordship has done his schooling in a government school. From there, His Lordship has rose to occupy the post of Chief Justice of India. I am sure that the road to the apex court to the country would have never been smooth for His Lordship, but he has worked hard and toiled himself to reach the pinnacle. Discipline, dedication, and determination are the most important virtues for anyone to excel in their field, and as our Honorable Judge possesses those qualities, His Lordship was able to reach the post that every lawyer aspires for. All the youngsters present here should take His Lordship as their role model not only in professional life but also in personal life. Even today, at the age of 75, His Lordship is doing agricultural activities in Erode. I pray Goddess Meenakshi to shower all her blessings on His Lordship and his family for leading a peaceful and healthy life. Thank you for the opportunity.
Thank you, ma'am.
May I now request Senior Advocate Mr. S. Meenakshi Sundaram to felicitate our Chief Guest, Hon'ble Mr. Justice P. SATHASIVAM, former Chief Justice of India, with a few words.
Respected and most honorable guest, His Lordship Justice SATHASIVAM, Honorable Justice Sundar, Honorable Justice K.K. Ramakrishna, learned senior advocates of the bar, junior advocates, and especially my respectable Madam Saraswati Sadasivam, the office bearers and the president of the function who has organized this. I first bid good evening to this function who have all participated. Of course, when I want to start my felicitation, I had prepared something, but it has been already told by my learned senior advocate Krishna Veni. But anyway, I would start from the beginning so that there are certain gaps which I can fill up. As far as the chief guest is concerned, he is a multifaceted personality. He started his career as an agriculturist. Thereafter, he rose as an advocate. Thereafter, he rose as a government pleader, special government pleader, and thereafter he rose to the post of Honorable High Court Judge, and thereafter he was elevated to Chief Justice, Justice of Supreme Court of India, then Chief Justice of Supreme Court of India, and thereafter he became Excellency, His Excellency, the Honorable Governor of Kerala. And again, he shows that life is a circle by turning back again, coming back to the original agriculturist. And His Lordship history shows, as my predecessor, that is my previous speaker told, that he as previous speaker means my president and as well as my learned senior friend told, life is a circle wherein it started as an agriculturist and it had ended in an agriculturist. His Lordship was born on 27/4/1949 in Kadappanallur village, Bhavani Taluk, hailing from a family of agriculturists. He is the first graduate in the family and first advocate from the village. He completed his degree course in Ayyanadar College, Sivagasi. He completed 3 years BL degree course in 1973. He enrolled as an advocate on 25/7/1973. He joined the office of senior advocate Thiru K. Doraiswamy. He was appointed as a government advocate on 26/10/1983. He was appointed as additional government pleader on 21/7/1988. He was appointed as a special government pleader on 27/7/1991. For a moment, the past. Your Lordship, when I say the date, you will see within the short period of time, he has been stepping the stone correctly. If you calculate the age from the date of enrollment in the year 1973 to his next step, it was very calculated, checkered career. Then he was appointed as special government pleader on 27/7/1991. He had helped the court to dispose of several batch cases arising out of the land acquisition proceedings, and he assumed the office of Honorable Justice of this Honorable High Court on 8/1/1996. Till 31/3/2007, he functioned as a judge of this Honorable Court totally. He did service exactly 11 years, 3 months and 8 days in this Honorable High Court. During this period totally, he has disposed of 22,783 cases as a single judge. Participating in the division bench, he has disposed of 13,609 cases. Sitting as a member of the full bench, he had disposed of 156 cases totally as a single judge, as a member of division bench, and as a member of the full bench. He has disposed totally more than 36,550 main cases and 50,709 miscellaneous applications. Among them, 851 judgments had been reported in reputed law journal. He was elevated to the Honorable Supreme Court on 21/8/2007. Thereafter, he was elevated as Chief Justice of India on 19/7/2013, and he retired as superannuation on 26/4/2004. He is a man who does not harm, insult, or insinuate, or either by words or by deeds. He is most virtuous human being. He is unique and unfavored. To him, help ever, hurt never, was not only the policy to be preached, but a principle to be practiced. This policy is always prevalent, even under extremely provocative situations. Patience and poise are not only his trait, but also a way of life for him. He had achieved many unique destinations. He is the first person to be elevated as a judge of the Hon'ble Supreme Court by the then President of Mr. Pradipha Patil. He is also the first judge of the Hon'ble Madras High Court to be elevated to the Supreme Court in the last 20 years, at that time without a tenure as a Chief Justice of Hon'ble High Court. Destiny has also his will that he was the first judge who came from the Hon'ble Madras High Court, later became the Chief Justice of India after the state reorganization. As Lordship assumed the office of the judge of this Hon'ble High Court, Hon'ble Supreme Court on 21/8/2007. He discharged his duties as justice with conscience or without any fear or favor. He almost dealt with all the branches of law with an exception of tax matters, but he had got a chance to decide the famous case, that is Commissioner of Income Tax versus Janahiram Mills Limited, reported in volume number 275 ITR 403. It is a case of reference to his lordship in view of conflicting opinions between the then Chief Justice and N.V. Balasubramaniam J. The said judgment of his lordship was appreciated as a landmark case by a retired member of the Income Tax Appellate Tribunal. After stating that an important decision has been rendered by the Hon'ble Madras High Court in respect of renovation, replacement expenditure found to be deducible as correct repairs under Section 31 or of even otherwise under Section 37 of the Income Tax Act 1961. After an elaborate review of the case laws, the critic concluded this way: the decision in Janahiram Mills case as a locus classicus on the subject, deserving the acceptance by the government without any reservation for more than one reason, by bringing a final closure to this unseemly controversy. Thereafter, after his lordship elevation to the Supreme Court, he has rendered many judgments, landmark judgments. Of course, my learned senior counsel had already quoted some judgment, but to my aspect, in a different angle I looked upon, and one of the famous cases is 2013 10 SEC page 1, that is People's Union for Civil Liberties and another versus Union of India and another, where we now exercise the nota, wherein your lordship describes about the democracy. Democracy is all about choice. This choice can be better expressed by giving the voters an opportunity to verbalize themselves unreservedly and by imposing least restrictions on their ability to make such a choice. By providing nota button in the EVMS, it will accelerate and the effective political participation in the present state of democratic system, and the voters in fact will be empowered. We are of the considered view that in bringing out this right to cast negative vote at a time when electioneering is in full swing, it will foster the purity of the electoral process and also fulfill one of its objectives, namely wide participation of the people. In the same judgment at para 55 he further states, giving a right to voter not to vote for any candidate while protecting his right of secrecy is extremely important in a democracy. Such an option gives the voter this right to express his disapproval with the kind of candidates that are being put up by the political parties. Now, we are using the nota button as on today, but here is the prelude where his lordship has delivered the judgment in 2013 10 SEC page 1. In another famous judgment in 2013 8 SEC page 593, Lalu Prasad versus State of Jharkhand, wherein he again how the democracy should be administered, and at the same time what about the position of an accused and especially of a politician. This has been very elaborately discussed, and thereafter he says about the independence of judiciary. Independence of judiciary is the basic feature of the Constitution. It demands that a judge who presides over the trial, the public prosecutor who presents the case on behalf of the state, and the lawyer amicus curiae who represents the accused must work together in harmony in the public interest of justice, uninfluenced by the personality of the accused or those managing the affairs of the state. They must ensure that their working does not lead to creation of conflict between justice and jurisprudence. A person, whether he is a judicial officer or a public prosecutor or a lawyer defending the accused, should always uphold the dignity of their high office with a full sense of responsibility and see that its value in no circumstance gets devalued. One another case regarding the very same particular, of course, in a different angle, their lordships has delivered a judgment in 2014 4 SEC page 473. Justice Ritsudan Dayal and others versus State of MP and others, wherein he states, it is clear that the basic concept is that the privileges, probably it may somewhat applicable in the present situation which is now prevailing in our state, it is clear that the basic concept is that the privileges are those rights without which the House cannot perform its legislative functions. They do not exempt the members from their obligations under any statute which continue to apply to them like any other law applicable to ordinary citizens. Thus, inquiry or investigation into an allegation of corruption against some of the officers of the Legislative Assembly cannot be said to be interfere with the legislative functions of the Assembly. No one enjoys any privilege against criminal prosecution. And the last one, which will be very sweet one for the Hon'ble judges, the judgment which His Lordship has delivered is 2014-12 SEC page 1. That is P. Ramakrishnan Raju versus Union of India and others. The dispute arose, rather a clarification arose, I may say, regarding how to calculate the pension of the retired High Court judges. Whether their services as an advocate, whether it can be computed or not, and how it should be computed. This is the crux of the point, and wherein it has been delivered. The petitioners have prayed that the number of years practiced as an advocate shall be taken into account and shall be added to the service as a judge of the High Court for the purpose of determining the maximum pension permissible. When persons who occupied the constitutional office of the judge, High Court retires, there should not be any discrimination with regard to the fixation of their pension. Irrespective of the source from where the judges are drawn, they must be paid the same pension just as they have been paid same salaries and allowances and perks as serving judges. The court accepts the petitioner's claim and declare that for pensionary benefits, 10 years practice as an advocate be added as a qualifying service for judges elevated from the bar. So these are the landmark judgments. There are many other landmark judgments, especially on the criminal side. There are a number of judgments. And apart from that, on the side of the representation of people act, the famous, that is the Nota case. And regarding the personal liberty under Article 21, there are also a number of cases. But if I quote everything, that will consume the most of the time. So I have shortened it. And the last one which I want to submit is regarding His Lordship's etiquette, behavior, and especially the encouragement given to the juniors who practice in his courts. High Court was always a convenient, nice playground to all junior advocates. Any junior can kickshot the boundary or sixers, provided he strucks the ball of helping hands of His Lordship. His court is a good turf with good pitch. His Lordship, after his yeoman service in judiciary, has begun his service on the administrative side as a constitutional functionary as His Excellency Governor of Kerala. He was a friend, philosopher, and guide to the Kerala government. I again stress, he was a friend, philosopher, and guide to the Kerala government as governor of then Kerala. Now he returned back to the pavilion by becoming an agriculturist. On behalf of the bar, I pray God let him have a peaceful and long life with blessings of Almighty.
Thank you, sir. Thanks for your wonderful words.
May I now request Senior Advocate Mr. T.S.R. Venkatramana to felicitate our Chief Guest, Honorable Mr. Justice P. SATHASIVAM, former CJ of India, with a few words.
கூட்டத்தினுடைய தலைவர் சீனிவாசராகவன் அவர்களே, இன்றைக்கு நம்முடைய சிறப்பினாக இருக்கக்கூடிய நம்முடைய மரியாதைக்கும் மதிப்புக்கும் அன்புக்கும் பாத்திரமான முன்னாள் தலைமை நீதிபதி ஐயா சதாசிவம் அவர்களே, அவர்தம் துணையாரே, இங்கே அமர்ந்திருக்கக்கூடிய நீதிபதிகளே, நண்பர்களே, சகோதர சகோதரிகளே, அனைவருக்கும் என்னுடைய வணக்கம். ஒரு கூட்டத்தில் மூணாவதாக பேசுறது கொஞ்சம் கஷ்டம். என்னென்னா இதுக்கு முன்னாடி எல்லாம் ஜட்ஜ் பண்ணி சொல்லிட்டாங்க. ஸோ நான் என்ன பண்ணலான்னு யோசிச்சுட்டே இருந்தேன். இவங்க எல்லாருக்கும் தெரியாத ஒரு ஜட்ஜ்மெண்ட் என்கிட்ட இருக்குது. ஏன்னா அது நான் நடத்தினது. திருநெல்வேலியில் மாவட்ட நீதிமன்றத்துக்கு அப்புறம் ஒரு 10 ஏக்கரை தமிழக அரசு மின்சார வாரியத்துக்காக அக்வயர் பண்ணாங்க. அந்த கட்சிக்காரருக்கு ஏற்கனவே நான் எம்ஏசி ஓபி நடத்தி மிக குறைந்த ஃபீஸ், அவங்க கொடுத்த ஃபீஸை வாங்கிட்டேன். அதனால் எல்ஏஓபிக்கு நீங்களே தென்காசிலேருந்து வரணும்னு கூப்பிட்டாங்க. நான் முதல்ல வேண்டானே, இல்லை அவங்க சொன்னதுனால சரின்னு போனேன். அதில் என்ன ஆயிடுச்சுன்னா, என்னுடைய கல்லூரி தோழர் நீதிபதியாக வந்தார். அப்போது எல்லாத்தையும் ஆர்கியூ பண்ணிவிட்டு ஒரு முக்கியமான கருத்து சொன்னேன். என்ன அப்படின்னா, அந்த அவார்டு பணத்துக்கு அந்த அக்விசிஷன்லேருந்து 10 வருஷம் கழித்து தான், அதாவது முதல்ல ஒரு நோட்டிஃபிகேஷன் போட்டு கேன்சல் ஆகி 2வது ஒரு நோட்டிஃபிகேஷன் போட்டு அது அக்விசிஷன்லாம் முடிக்கும் போது கிட்டத்தட்ட ஒரு 15-20 வருடம் ஆகிவிட்டது. அப்போது ஆக்ட் 64/84 என்று சொல்லி லேண்ட் அக்விசிஷன் ஆக்டில் ஒரு அமெண்ட்மெண்ட் வந்து டேட் ஆஃப் பொசஷன்லேருந்து டேட் ஆஃப் பேமெண்ட் வரைக்கும் இன்ட்ரெஸ்ட் கொடுக்கணும் அப்படிங்கிற பாயிண்ட். அது வந்து மெயின் ஆக்டில் இல்லை, பட் அந்த அமெண்டட் ஆக்டில் ஒரு தனி செக்ஷனாக இருந்தது. இதை என்னுடைய சார்பு நீதிபதிகிட்ட ஆர்கியூ பண்ணேன். அவர் எனக்கு அதை கொடுக்காட்டாலும் பரவாயில்ல, சட்டத்திலே இல்லாதெல்லாம் வெங்கட்ரமணன் சொல்கிறான்னு சொல்லிட்டார். ரொம்ப வருத்தப்பட்டேன் நான். ஆனால் இதே வழக்கு சதாசிவனிடத்திலும் அப்துல் சதார் அவரிடத்திலும் வந்தது. முழுமையாக ஆர்கியூ பண்ணேன். அவங்க ரிட் அப்பீல் அலோவ் பண்ணிட்டாங்க. அதில் மட்டும் இல்லை, கவர்மெண்ட் கொடுத்த அந்த அடிப்படை காம்பன்சேஷனுக்கு மேலே கவர்மெண்ட் அப்பீல் வந்ததுக்கு அந்த கவர்மெண்ட் அப்பீலை டிஸ்மிஸ் பண்ணி என்னுடைய அப்பீல் அலோவ் பண்ணாங்க. தீர்ப்பு வந்தோட ரொம்ப மகிழ்ச்சியாக வாங்கி படித்தேன். கொஞ்சம் காற்று போன பலூன் மாதிரி ஆயிடுச்சு எனக்கு. என்னென்னா, அந்த இன்க்ரீஸ்டு அமௌண்ட்டுக்கு அந்த ரெட்ராஸ்பெக்டிவாக இந்த டேட் ஆஃப் பொசஷன்லேருந்து டேட் ஆஃப் காம்பன்சேஷன் கொடுக்க வேண்டிய அந்த 12% அடிஷனல் அமௌண்ட்டை கொடுத்துறாங்க. பட் அந்த ஏற்கனவே அவார்டில் இருந்த பணத்துக்கு அது வரல. அது கிட்டத்தட்ட 1 கோடி ரூபா. அது எனக்கு என்ன பண்ணுன்னு தெரியும். நான் அப்போ தான் ஒரு முன்சி கோர்ட்லேருந்து நான் ஹைகோர்ட்டுக்கு வந்திருக்கிறேன். நேராக உடனே அன்றைக்கி நைட்லேயே பஸ்ஸை பிடிச்சி எங்கள் அண்ணனை போய் பார்த்தேன் மெட்ராஸில். அவர் சொன்னார், அது அப்படி தவறு நடக்க வாய்ப்பு இல்லையே, நீ நல்லா சொல்கிறியா அப்படின்னு முதல்ல என்ன தான் கேட்டார். ஸோ சொல்லிவிட்டு சரி, அப்போ நான் அவரை கன்வின்ஸ் பண்ணேன் இந்த மாதிரி. அப்போ நீதிபதியை நேரில் போய் பாரு அப்படின்னாங்க. எனக்கே பயம் இருந்தாலும் போனோடனே, என்ன வாட் இஸ் த மிஸ்டேக் யூ சே ஐ ஹவ் கமிட்டட்னார். இல்லை மிஸ்டேக்கெல்லாம் இல்லை, ஒரு சின்ன எரர் அப்படின்னு. தென் ஃபைல் ரிவ்யூ அப்படின்னார். நான் சொன்னேன், ரிவ்யூ போட்டால் அதுக்கு எவ்வளோ காசு கட்டணும்னு எனக்கு தான் தெரியும், 7.5%. ஸோ நான் என்ன பண்ணேன், ஒரு அமெண்ட்மெண்ட் ஆஃப் தி ஜட்மெண்ட் அண்ட் டிகிரின்னு ஒரு விஷயம் போட்டேன். மிக பெருந்தன்மையாக அதை அலோவ் பண்ணி, ஏன்னா கட்சிக்காரங்க பாதிக்கப்பட்டிருக்காங்க. ஏன்னா அன்றைக்கே அது வந்து சென்ட் லட்சம் 15,000 ரூபாய்க்கு போயிட்டுருக்குது. இவங்க 1,500 ரூபா கவர்மெண்ட்டில் காம்பன்சேஷன் கொடுத்தாங்க. அந்த ரூலிங் வந்து இவங்க நிறைய ரூலிங்லாம் சொன்னாங்க, நமக்கு அவ்வளோ ஞாபகத்துலாம் வயசு வேறு ஆயிடுச்சு. அதில் வேறு ஒரு முக்கியமான விஷயம், நண்பர் மீனாட்சி சொல்லும்போது தான், அவங்க 1973 அவங்க வந்து என்ரோல்மெண்ட் ஆனாங்க அப்படின்னோடனே, அப்போ இது உங்களுடைய 50வது ஆண்டு விழா நீதித்துறையில். ஏன்னா அடுத்த வருஷம் எனக்கு, ஏன்னா அந்த கணக்கு எப்படி வந்துச்சுன்னா அடுத்த வருஷம் எனக்கு 74, நான் 74 என்ரோல்மெண்ட்டு. ஸோ ஒரு வருஷம் கழிச்சு அப்போ இந்த வருஷம் 50 கம்ப்ளீட் பண்ணிட்டார் அப்படின்னு தெரிஞ்சுது. ஐயா வாழ்த்துக்கள். அது ஒரு மிகப்பெரிய உங்களுடைய 50வது ஆண்டு பொன்விழா ஆண்டு. வாழ்க்கையில் வந்து பொன்விழா என்பது, ஏன்னா இந்தியா சுதந்திரம் அடையும் பொழுது இந்தியனுடைய சராசரி வயசே 37 தான் இருந்தது. இந்த நாடு வளர்ந்துருக்குது, சந்திராயன் போய் நேற்றுக்கு லேண்ட் ஆச்சு எல்லாம் சொன்னால் அதற்கு காரணம் இந்த நாட்டினுடைய வளர்ச்சி. அதில் நீங்கள் 50 ஆண்டுகள், எனக்கு 1 வருடம் முன்னதாக நீங்கள் வழக்கறிஞராக பணியாற்றி இன்றைக்கு நீங்கள் உச்சநீதிமன்றத்தில் நீதிபதியாக தலைமையாக, அது மட்டும் இல்லை, இன்னொன்று அந்த ரூலிங் சொல்கிறேன். 2005 CTC பேஜ் 23 டிவிஷன் பெஞ்ச். ஏன்னா அந்த அமெண்ட்மெண்ட், அது அமெண்ட்மெண்ட்டுக்கு முன்னாடி என்ன நடந்துன்னு சொன்னால் நிறைய நேரம் ஆகிடும். ஜஸ்டிஸ் இப்ராஹிம் கலிஃப்லாட்டை வந்துச்சு அது, அந்த அவர் பிடிச்ச அந்த பிச்சு பறக்க விட்டார். நானும் எவ்வளோ சொல்லி பார்த்தேன், இல்லை. அப்புறம் ஒரு லெவல் தாண்டினோடனே தவறுன்னு தான் சொல்ல முடியும், வேறு என்ன சொல்ல முடியும் அப்படின்னு கேட்டேன். அப்போது அவர் நாளைக்கு நான் படிச்சுட்டு வரேன் அப்படின்னு சொல்லிட்டு ஒரு ரூலிங் கொண்டு வந்து கொடுத்தாரு. கொடுத்தோன்னு நான் சொன்னேன், இந்த ரூலிங் எனக்கு சாதகமாக இருக்குது அப்படின்னு. அவள் எப்படி சொன்னாங்கன்னா, அப்போ யூ ஷுட் பே மீ ஹாஃப் ஆஃப் தி ஃபீஸ்னர். ஐ சே யூ டேக் த ஃபுல் ஃபீஸ் பட் அலோவ் மை ரிவ்யூ பெட்டிஷன் அப்படின்னு சொன்னேன். ஆனால் அவங்க சொன்னாங்க ஜட்ஜிட்டே போடுறேன்னு சொல்லி. அதில் என்னென்னா, நான் அந்த இதை சொன்ன உடனே நீங்கள் இருங்க அப்படின்னு சொல்லிட்டு, அப்போது சர்தார் சையத் நினைக்கிறேன், அவங்க ரிட்டையர்ட் ஆகிட்டாங்க, மதிவானந்த் ஜே சிட்டிங்கில் இருந்தாங்க. இவங்க அது எல்லாத்தையும் எக்ஸ்பிளைன் பண்ணி சொல்லி அதுக்கப்புறம் டிக்டேட் பண்ணாங்க. அதுதான் அந்த ரிப்போர்ட் ஆன ரூலிங். அது என்ன சொன்னால், இன்றைக்கு நிறைய நம்ம நீதிமன்றத்தில் பார்க்குறோம், வக்கீலோட ஜட்ஜு நிறைய பேசுகிறாங்க அப்படின்னு சொல்லுவேன் நான். ஆனால் பொறுமையாக கேட்டு அதை ஒரு கட்சிக்காரருக்கு அவருக்கு அலோவ் பண்ணதை என்னால் மறக்க முடியாது. அதே மாதிரி நம்மளுக்கும் ஆசை கனவுகள் டெல்லிக்கு போகணும் அப்படின்னு போனேன். குற்றாலத்துலேருந்து டெல்லிக்கு போகிறது எவ்வளோ பெரிய தப்புங்கிறது போனப்பறம் தான் தெரிஞ்சுது. செஸ்ட்டில் வந்து இன்ஃபெக்ஷன் வந்துருச்சு. இருந்தாலும் அவங்கள ஒரு நாளைக்கு பார்க்கும்போது, நீங்கள் சேம்பருக்கு அப்ளை பண்ணிட்டீங்களா அப்படின்னாங்க. இல்லை பண்ணலை. என்ன பண்ணுங்க, அதுக்கு உங்களுக்கு அது சீனியாரிட்டியில் உங்களுக்கு கிடைக்கும் அப்படின்னாங்க. ஆனால் அந்த பாக்கியம் எனக்கு, ஏன்னா அந்த என்னுடைய டாக்டர் சொன்னார், உங்களுக்கு டெல்லியா அல்லது உயிரா அப்படின்னு கேட்டார். அப்போ ஆப்வியஸ்லி நம்ம சாய்ஸ் உயிர் தான் அப்படின்ட்டு வந்துட்டேன். அன்றைக்கு இது இந்த நேரத்தில் எதுக்காக சொல்லுன்னா, ஏற்கனவே எத்தனையோ வழக்குகளில் தீர்ப்புகளெல்லாம் சொன்னாங்க, எவ்வளவு பண்ணாங்க. இன்னொன்று அவங்களுடைய சிறப்பு ஒன்று சொல்லணும்ல, தமிழகத்தினுடைய மிகப்பெரிய ஒரு அரசியல்வாதி இறந்து போனாங்க. அப்போ அவங்க கவர்னராக இருக்காங்க, தமிழ்நாட்டுக்கு வராங்க. ஏன்னா அஞ்சலி செலுத்துறதுக்காண்டி வரணும். வரும்போது எப்படி வந்தாங்க அப்படின்னா, வெறும் கவர்னர் மட்டும் வரல, கேரளா கவர்னர் மட்டும் வரல, கேரளாவினுடைய முதலமைச்சரையும் கேரளாவினுடைய எதிர்க்கட்சி தலைவர் 3 பேரும் வந்து அந்த ஃபங்க்ஷனில் கலந்துக்கிட்டாங்க. அப்போது எந்த அளவுக்கு வந்து அங்கே இருக்கக்கூடிய அரசியல்வாதிகளோடும் அரசியல் தலைவர்களோடும் அவர்கள் வந்து, அதோட வெறும் தமிழ்நாட்டுக்கு வரவங்கிறது மட்டும் இல்லாமல் அந்த ஒரு ஃபுல் கேரளாவே வந்து அங்கே வந்து அவருக்கு அஞ்சலி செலுத்திய மாதிரி அவங்க செய்த என்னென்ன நான் டிவியில் பார்த்துருந்தேன். என்னால் மறக்க முடியாது அந்த ஒரு சம்பவம். வந்து இது மாதிரி சொல்லிகிட்டே போகலாம். இருந்தாலும் நீங்கள்லாம் அவர் பேசத்தான் கேட்க வந்துருக்கீங்க, நான் ரொம்ப நேரம் பேச முடியாது. மேலே வாய்ப்புக்கு நன்றி சொல்லி விடுகிறேன். நன்றி, வணக்கம், ஜெய்ஹிந்த்.
Thank you, sir, for your kind and energetic words.
May I now request the Administrative Judge of Hon'ble Madurai Bench of Madras High Court, Hon'ble Mr. Justice S.S. Sundar, to felicitate our Chief Justice, Hon'ble Mr. Justice P. SATHASIVAM, former CJ of India, with a few words.
Honorable Mr. Justice SATHASIVAM, former Chief Justice of India, my companion judges, and Mrs. SATHASIVAM, and the senior members of the bar office bearers of all the 3 associations. Good evening to everyone. I am the 4th speaker. I have also got actually a list of judgments actually. Therefore, to shortcut actually, I just want to make 2 corrections. Senior Counsel T.R. Venkatramana in his speech actually referred to the amendment in 1984, that is probably section 23(1) capital A, where interest actually 12%. He referred to actually the fact that he lost before a judge, which according to was his colleague actually. Probably he was referring to Justice Ibrahim Khalifullah. He happened to be his actually. I don't know. Because Justice Ibrahim Khalifullah also belongs to the same batch. I don't know. Your batch, isn't it? Oh. He is the first graduate in his family, and he is the first advocate. He raised to, because he completed his law in Madras Law College and thereafter immediately practiced under Senior Counsel Mr. Dorasamy. So we used to find actually him always lucrative. I have seen him in my own eyes actually, how he used to busy running between courts like that. So his practice in motor accident claim tribunal is amazing, I know. And then just few days before his elevation, he was asked to appear before Justice M. Srinivasan. So with the same sense of actually as an advocate, dutiful advocate, he was present in that court on that day. I can't forget actually the incident. So such a humble man in his beginning. Now talking about his actually his legal acumen, he always actually tried to answer every point that is answered before him. So we are now, judges are judged by their own judgments. When I'm actually, we were all comfortable when we argued the case, present the case before actually. He is a very good analyzer, and then always we will be surprised when we don't actually present the case facts properly. Because in land acquisition cases actually, those cases, you always remember one particular rule, Rule 3B, in all acquisitions relating to housing board. So there is a requirement by which the objections will be forwarded to the requisition department. The requisition department are expected to offer their remarks to the objection. When the objections are considered on the basis of remarks offered by the requisition department, without holding further inquiry, then that is actually an infraction of Rule 3B that is settled by question. So when we present the same case before him, we will actually put two embarrassing questions. Whether, have you filed objections within 30 days? If you don't file objections, yes, you will be. So these are all actually things, so we will have to be now careful in presenting the case. Same way, so a very serious argument was advanced while challenging the constitutional virus of Somasabam Super Spinning Mills case actually. The argument was by actually Justice Sudhagar, and I was actually a junior. So I prepared actually all my written arguments in the notes and before him. So the judgment was meticulous. That gave everyone reading the judgment, if I appear actually and then quoted all these points, everything was considered. It's a very beautiful, nice judgments. Anybody will appreciate. Not only the honorable judge, but also the counsels who are arguing the case. This is the way in which actually used to narrate events in every judgment of him, and then it is always it will be good for reading, first of all, to understand what exactly the issue that was considered, fair to everyone who was present in the case, and this is the quality of our Lordship's former CJ. And then I'm grateful that he has now become, former CJ has become actually a farmer, and then we see his actually valuable advice to farmers as a farmer now. So he gave several tips. Probably he wanted actually the government to look into the problems, real problems of the farmer now. So in one of his actually, the problem faced by the present day agriculturist farmers is something actually, because he could make valuable suggestions, and then because of time factor actually I don't want to continue more and then about. I only say a few things about actually His Lordship's the caliber as a judge. So there were instances where I'm also not only land acquisition cases, but in relation to one instance I will just actually narrate and then complete for that. So there was a enactment called Tamil Nadu Preservation of Private Forest Act. So we have a case challenging a notification issued under the provisions of the Act. The collector or a committee under the headship of collector is the authority to issue a notification declaring any private land as a private forest. So then it will come into the purview of Act. So this, we are challenging notification. It came before Justice Vaivangadachalam. So incidentally, we challenged the three provisions of the Act. So therefore, actually, he declared the three provisions as invalid on the ground, peculiarly, on the ground that actually violation of principles of natural justice. Farmers are given actually. So then it came before actually, yes, the division bench consisting of, after remand, of course, so the matter was considered and it's a well-considered judgment and nobody can quarrel with actually. So the way in which actually heard us and then answered every point actually, I'm still remember some of the aspects of the case. So you always used to respect to every counsel's, the meticulousness in preparedness, actually you will make a record of it and thereafter deal with the issue. This is a great actually, the quality of our former CJI. With that actually I conclude, I wish him only a long, happy, and healthy life. Thank you.
Thank you, Lordships. Justice Charles Evans Hughes, the 11th Chief Justice of the United States of Supreme Court, said that an honest, high-minded, able and fearless judge is the most valuable servant of democracy. If greatness consists in the combination of character and intellect of the highest order, and if it is to be measured by the lasting value of solid works done in the fields of thought and action, our Chief Guest, Hon'ble Mr. Chief Justice P. SATHASIVAM, former Chief Justice of India, is definitely one of the most outstanding judges and men of our times. Even retirement has not been able to rupture his sense of public duty and moral vision, and he is amidst us today to share few words. May I now request Honorable Mr. Justice P. SATHASIVAM, former CJ of India, to deliver his special address to the gathering present here.
Honorable Mr. Justice S.S. Sundar, Administrative Judge of the Madurai Bench of the Madras High Court, other Honorable Judges of the Madurai Bench, officers of the Registry, most respected Mr. T.S. R. Venkatramana, S. Meenakshi Sundaram and Madam Krishnaveni, Mr. S. Srinivasa Raghavan, President, and Ayiram K. Selva Kumar, General Secretary, other officers of the MMBA and other associations, and my dear advocates, good evening to all. I will also mention the same thing. I am a fifth speaker or the last speaker. No, I have also noted these judgments. Since all of you have already mentioned, now I am not going to narrate my background, farming, etc., etc. But my journey started as a farmer's son. So other things, I studied in a government school, Tamil medium only. Then after finishing graduation, when I joined Madras Law College, I started getting English newspaper every day to my room. When I was in the house, I started reading Hindu because since my whole school and college everywhere, mostly in Tamil medium only. So thereafter I learned good English. Then I enrolled as an advocate. Other details, all the earlier speakers have mentioned. I am not going to say anything. But some of the important judgments mentioned, all of you, including my respected brother Judge Justice Sundar, regarding Reliance Gas, everyone mentioned, that was a dispute among the Ambani brothers. My colleague was Justice Chauhan. So after going through the papers, this is an important event. So we are, many of you may not aware, we are getting plenty of natural resources in Bay of Bengal, Arabian Sea and Indian Ocean. We have well-established public sector undertakings. Unfortunately, this was being utilized only by these companies. So whatever may be, it is for the government. We cannot say all these things. But in order to solve the issue, we summoned both the brothers and their mother to the court. Now at that time, I was heading the Supreme Court as the Chief Justice of India. They came to my court. All three were seated in the front row. Then after negotiation, they agreed for a settlement. So we finalized the case. In that, while delivering judgment, I made an observation, not a direction to the elected government. It is for the elected government to take a policy decision and implement. So the courts cannot dictate them to do it or not to do it. But I made an observation, myself and Justice Savan, mentioning all these public sector undertakings. They are, at that time, they were functioning well. In order to develop more employment opportunities, it is better to encourage public sector undertakings. With that, we said the last sentence, it is for the appropriate government to take a decision. So we made only observation, but unfortunately that has not been implemented. Now, one by one it is going to private hand only. Then another one, everyone mentioned Mumbai blast case, 1993. Here also I have to mention one thing. The trial went for 13 years at Mumbai. That was the first blast in India. That was in the judgment itself I have mentioned this. The This was planned in our neighboring country, how these AK-47 guns were entered Mumbai port, etc., everything we mentioned. Then after 13 years, they convicted 13 persons to a death sentence, and everyone mentions Sanjay Dutt awarded 5 years, 3 years by the court, only we increased it. After conviction, because TADA provisions have been included, the High Court has no jurisdiction to hear the appeal. That is the problem. Appeal lies straight to Supreme Court. So at that time, the Chief Justice was Justice Kapadia from Bombay. Very difficult to easily meet him or interact casually. Even his colleagues have to get an appointment, then only the judges were allowed to enter his chamber. So suddenly during lunchtime, his private secretary came to my chamber. My Lord, Chief Justice of India wants to meet you. Please come at 4:30 over a tea, you want to discuss one issue. Then I was little shocked. I don't know what is the mistake I committed. Why CJI is summoning me, asking me to come and meet. Then I went there. He offered a cup of tea. Then he said, brother, this is a very big case heard by the Bombay court last 13 years. So we have received records. Parties have filed appeals. So I am thinking of entrusting this matter to you. And that is the privilege I am mentioning. He mentioned, I am giving an opportunity to select a companion judge of your choice. It never happened in any court. It is a prerogative of the Chief Justice. Then I said, sir, Chief, I am thankful to you, though I like all the judges, but in order to get more assistance, I prefer Justice P.S. Chauhan. Then he constituted the same bench. Within a week, the case has been listed. Before that, I asked my secretary, Madam, you send those records and judgment copy of the trial court. I am going for a vacation, so in my village I can go through and read. Then she was standing like a tree. I asked, why you are not responding? My Lord, if I want to implement your Lordship's direction, I have to secure a lorry to send all the... Because more than 60,000 exhibits and judgment alone, thousands of pages. Then I said, leave it. And then I returned. First day we mentioned in the cost list itself, till this batch is over, we are not going to hear any other matter. 10:30 to 4 o'clock, only this Mumbai blast case, no adjournment, no passover. Then we heard this matter for 10 months continuously. After reserving this judgment, within 4 months, we delivered a judgment. The judgment alone running into 1,200 pages. The All India reporter AIR printed the judgment in a separate volume. In the docket, separate volume, in the docket, first page, it is mentioned the biggest case ever heard by the Supreme Court, delivered by so-and-so. They mentioned my name and Justice Chauhan. On the date of retirement, after retirement, the publishers came to my house, they handed over that copy. Sir, you keep it in your house. It may give some encouragement to you. That I accepted. When I settled in my village, I returned all my law books purchased from 1973 to 2014 to Erode District Court Library. They mentioned my name and opened a library. I retained this judgment alone. Even now, sometimes I take up or go through it, how able to collect these materials, only for that. Another thing is another thing I can proudly say, it's a Rajiv Gandhi assassination accused case. You know, the Supreme Court itself confirmed the death sentence. They deserve death sentence. Nobody can kill anyone, including Prime Minister of a country. But That is the Constitution of India. In our Constitution gives same right to death convicts also. Most of you might not have visited death cell. I had an opportunity to see the cell personally. You can't see outside. Only the window will be at the ceiling level. These persons, after confirmation of death sentence, sent a mercy petition, Karunai Manu, to the President. That was kept pending for nearly 8 years. So they challenged by way of PIL under Article 32 of the Constitution directly to the Supreme Court. When we issued a notice to the central government, unfortunately, the then Home Ministry mentioned, sir, this incident happened in in the South India, that is in part of Tamil Nadu. We have to collect records and take all those records to Delhi, to our office. That's why it. So now I said every day 3 or 4 flights from Delhi, Chennai to Delhi, within 3 hours you can bring, or even if put everything in a lorry, it will reach within 4 or 5 days. Why 8 years? In the absence of proper acceptable reason, we quoted international law. India is a party to those conventions, quoted a convention, international convention, and we mentioned in the absence of acceptable reasons, even death convicts are also entitled more benefits under our Constitution. So at this stage, at that time, they were in jail for nearly 27 years. We said it is not proper to execute them. We modified death into life, and we also mentioned it is open to the appropriate government to take a decision considering their length of service in the jail. That may be the reason. Subsequently, now all of them have were released from the. Now, why I am not for this I mentioned. So, you know, as a Chief Justice of India, when I retired, the President of India hosted a dinner inviting Prime Minister, Vice President, everyone. That is usual. That happens to everyone. After 1 week, when I was staying in the same official residence, as per a Supreme Court procedure, the retired judge can stay for 1 month. Now, I stayed 2 weeks. First week, I received a phone call from the Secretary to the then President, Mr. Pranab Mukherjee. Sir, President wants to talk to you. Then he asked whether any relatives are with you, sir. Now, I said, no, myself and Madam alone are at Delhi. Please come for lunch on a particular day. Then we went there. He invited his daughter, son, other family members. Provided a sumptuous lunch. Then asked his daughter to take my wife to some Mughal garden and spend some time. He took my hand to his office room. He asked me to sit in his chair. See, on the right side, I am keeping your judgment. Whenever any mercy petition comes, that will remind me, don't delay it. Now I said, sir, you are not delaying it. Only the Home Ministry has to forward it. And if there is an acceptable reason, then delay can be. So I explained to him. Anyhow, he kept that judgment on my right side. So I can proudly say. The other thing, one day in a crowded court, I noticed an advocate wearing black clothes in the front row, not able to sit or argue. Then I conveyed to my sister judge, Ranjana Desai was my partner at that time. Then he asked, what is the matter? Why you are standing here in the front row? Then only we came to know he is 100% blind advocate. With the assistance of someone, he mentioned, sir, we means disabled persons have several difficulties. I have filed a PIL, please consider. Immediately, even without looking into the paper, with the consultation, we issued a notice to all state governments and the Union of India. Within a month, we heard once again. Then issued various directions. several directions. Maybe after that judgment only, we mentioned the statistics, how many disabled persons in India, employment opportunity, etc. At that time, the reservation was 3 persons. We very politely, humbly made a suggestion to the Parliament, it is proper to consider. Next session, they increased 3% to 4%. And in that order, we issued a direction, year after, all government offices, either state or center, they have to provide a ramp. Whenever you walk on the ramp, you have to think of me. That is a mandatory. Likewise, several directions. I am mentioning only one. And we also said, hereafter, we should not call them as disabled. They are all specially abled persons. So that also I can proudly say. And prohibition of manual scavenging. We only, by way of PAL, prohibited hereafter, no question of someone going into the manhole and take. So they have to use machineries. Issued a positive direction. In case any death happens in that, the family has to be paid 10 lakhs. Now I saw only in Kerala, they immediately invented, they open a manhole, put that machine, within 2 minutes the block will be removed, everything will be. I don't know the position in Tamil Nadu. So that also I can proudly say. Another is also MP lad judgment. MP lad, Member of Parliament. MP and MLA, they are getting fund for development in their constituency. That was challenged by another MP from Kashmir, Jammu Kashmir. I think I have forgotten his name. He engaged Mr. Venugopal as his counsel. It came up before then Chief Justice Balakrishnan. I was sitting with him. Before hearing the matter, I can humbly convey to the CJI, sir, it is very an important issue. It is going to be a tussle between elected government and the judiciary. Why not be subject to your approval? Why not be referred to Constitution bench? He readily agreed, and the Constitution bench was constituted. I was a 4th judge. Mr. Venugopal argued from 10:30 to 3 o'clock. Almost he convinced all the judges except myself. I didn't agree. Then another 1 hour, then Attorney General came and completed his argument. You know the practice in Supreme Court, all important cases heard. All the judges will go to the senior judge chamber. Over tea, they express their views. In that they express, other 4, as usual as a South Indian, in a humble way I mentioned to the CJ, sir, these are all the things. According to me, it is a valid piece of legislation. I explained, I come from a rural base. I know the sufferings of the people. Suppose if the elected MP or MLA is opposition party, he or she may not get any scheme. So at least if his fund goes, he can do something, toilet, roads, something, library, etc. This is one. Number 2, several safeguards are there. I argued like petitioner's counsel. One, if it is in a mofussil, the collector has to see this request and personally inspect and give approval. If it is in city, the commissioner corporation has to do the same thing. So second safeguard. Third one, after finishing the work, if it relates to member of parliament, all the documents, tender document, etc., have to be forwarded to the parliament secretariat. If it is MLA, it has to be forwarded to the state legislature. So several safeguards are there. Now Right to Information Act is there, everyone can question. According to me, I humbly say it is a valid piece of legislation. We have to respect the elected members. They are answerable to their voters, not you and I. When I visit, nobody will come and complain. But MLA and MPs are answerable to their people. All 4 agreed, and the Chief Justice said, brother, you prepare a judgment. 77 page within a week I prepared. I even summoned Parliament Secretary to my residence, bring all the GOs, other copies he supplied, I mentioned. Then all four agreed. It is a unanimous Constitution bench judgment. After delivery, that's why I am telling. Morning, next day after seeing the newspaper, about 10 MPs came to my house. At that time, I was in number 5, Krishnaman Mark, Chief Justice residence. My security, they are not allowing, because no appointment, we can't allow anyone to enter. Then I said, they are all MPs, let them come. Then I said, no need to come. They came to convey their thanks. Sir, you are the only judge, recognized our role. You said the elected members have, elected government has more role. So this is very encouraging. So we want to convey our thanks. Now I said, don't do it. It is our duty. It is there in our Constitution. So after serving tea, I asked them to convey my thanks only. That's all. Another thing, this nota everybody mentioned. See, very important PIL. One day one person argued, see, in my constituency, A party, B party, C party. I am not, everyone is having some complaint or something. I have no respect for them. How can I cast my vote? Can I throw it? So he raised a valid point. Then we summoned Chief Election Commissioner, at that time Mr. Krishnamurthy from Tamil Nadu. I asked him to bring that machine also. In the court itself, we spent more than 2 hours. Then he suggested, we demonstrated. He demonstrated, I accepted. And the last, we can put this nota. If somebody put that button, it will show that if more votes are there, it may give a message to the political parties, then at least for next time, they will select a good candidate. That also. Then VVPT, that is Voter Verified Paper Audit Trial. That also my direction. When you select a candidate, how do you say that you have selected a correct person, whether that has gone to the correct symbol, correct name. So that also we directed the election commissioner to come to the court. He demonstrated. Next to the same small slip will come. Now they are, I think they have introduced to all assembly and parliamentary constituency. It will see 10 seconds or 15 seconds, again it will go down. So this is also one proof. Another thing also very important, nobody mentioned, the candidate has to mention the movable and immovable properties, name and other details of not only himself, his wife and minor children if any. So many, before 3 months or 6 months election, they transfer to wife's name or somebody's name. Now that cannot be possible. So all these things I can say, but not required. Then as a governor of Kerala, now thereafter 5 minutes I will finish up some request to the members of the bar and honorable judges. In the Kerala, I formulated a Chancellor's Award. There are 13 universities. Best university every year. I requested Chief Minister, sir, I will select a best university. Let us give some amount to encourage. So 5 crores prize money plus certificate. I constitute a high-level committee. They will inspect and submit a report. Everyone appreciated. Even in the governor's conference, the present Prime Minister and former President mentioned to other governors, if possible, follow this method also. I can. Then the Law University conferred a doctorate, etc. And I am not going to elaborate. Then attending conference like this is mandatory. Unfortunately, now I expected for a Madurai bench, there may be auditorium. So only very small auditorium. Yes. Because hearing speeches from honorable judges, senior advocates, is an important for young and upcoming lawyers. No, I can proudly mention, as a young lawyer in 1973, I heard, standing in a corner of a court, I heard the arguments of Mr. Parasaran and Mr. Venugopal. This Mr. Parasaran mentioned in the open court one day. Finally, later, I had the opportunity to decide their merits as a judge of the High Court and Supreme Court. When he was arguing in Supreme Court, one day very politely, very humbly, Mr. Parasar mentioned, now our argument's destiny in your hand. I saw you as a young lawyer standing in a corner taking notes of our arguments. Now I take it is a appreciation for me. Then, as a member of the bar for 23 years and nearly 19 years in the bench, namely 2 high courts and Supreme Court, finally as a head of the judiciary, I have a great respect for the judiciary and an abiding interest in protecting its role in our democracy. Only one information I have. This Reliance Gas I mentioned appreciating public sector undertaking. On the date of retirement, in the farewell address I mentioned, maybe after 1 or 2 weeks, I am going back to my village. I want to continue my farming. No, it has come as a big news in the next day newspaper. After knowing this, almost more than 7 or 8 public sector MDs and chairmen came to my house. Now I asked, what is the purpose of meeting me? Now I am a retired person. No sir, we have gone through your judgment. You encouraged public sector. So why you are going to village? We have thousands of crores of money have to be recovered from many corporate houses, particularly foreign companies. You stay at Delhi. We will provide accommodation in our guest houses. Everything we will provide, give legal opinion and arbitration matters. Now I said, this is my personal view. Others did not take it. After retirement as a Chief Justice of India, again going back to the legal profession, it is personal view. Because one of my colleague, and I won't mention his name, he succeeded as a Chief Justice. When an advocate argued, my lord, my argument is based on the opinion of former Chief Justice of India. So unfortunately, my colleague said, it's still worse. He openly, after mentioning this, then only I said, same thing may happen tomorrow to me also. Why should we get this? Of course, very unfortunate. The same judge is now doing the arbitration at Delhi. Now I won't disclose his name. Then these MDs tried my level best. Now I said, I am not interested. It is my personal view. I have to take care of my own lands because my 2 children were out of my village. I have to look after my lands. Then very off of mind, they about to leave. One person again came. See, boldly he mentioned, sir, we know your last drawn salary as a Chief Justice of India. At that time I was sitting alone. If you accept our suggestion, you may get 20 times of your last drawn salary per month. Now I said, fortunately my wife was not there. She was inside the house. Otherwise she could have persuaded me to accept. Then I said, my pension is sufficient. So I conveyed, that is one thing. Then members of legal fraternity should remember that apart from their duty towards their clients, they perform public duty as well as officers of court in furtherance of cause of justice. They should always keep in view the larger objective of advancement of public morality, truth and justice, and instill confidence in the public. They have to scrupulously abide by the code of conduct prescribed by the Bar Council of India. Cooperation between the bench and bar is fundamental necessity. A lawyer should not forget that he is not only fighting the battle for his client, but he is assisting the court in the administration of justice. Then I don't want to mention the constitutional provisions, but at least one occasion, once in 6 months, once in a year, you must help some poor persons or disabled, so many other persons, they have a litigation. So why I am mentioning, 1 month back, one disabled person, he is working in a government office in Dindigul. I don't know, maybe after reading my order, everything, he took another disabled person. He is 100% blind. The other person who accompanied, he has some leg problem. With the assistance of another person, these two came to my village, from Dindigul to my village. I noted his name is Satyago. He is 100% blind working in Dindigul collector's office. Some issue, he filed a case, even that was heard by Madurai bench, everything went in his favor. Now after 3 rounds, the government filed a SLP, that was also dismissed in Supreme Court. But afterwards they filed a review, that is still pending. So he came to my house, sir, I cannot go and defend my case. I cannot spend, I am 100% blind, disabled. Then I said, why you came here? Everywhere, even in Dindigul, in the court complex, legal service authority is there. Or go to Madurai bench. Their legal service authority, they will definitely, after noting down details, they will engage a counsel. You need not spend any money. So in the morning, I mentioned these details to one of the registry officer. I think he requested me, sir, convey this to the, I think morning I mentioned. Another problem, of course, here all advocates are in the High Court. Notorious problem in the trial courts in granting frequent adjournments. I am not going to mention CPC provision, how many times adjournment can be given. But why I mentioned in one function last time, see, when I retired in 2014 after finishing the governorship for 5 years, when I settled in my village, next day morning I went round my garden, 30 acres of land, very adjoining to Kaveri River in Erode district. Then after my land, about 14 acres, beautiful lands, but all big, this, what is that, Vella Vela Maram, Vella Vela or Karuvela Maram, very Marama. Now I inquired, why, sir, here we have filed a partition suit. It is pending for 14 years in Bhavani Court, additional district court. 14 years partition suit. No, don't mistake me. Then I asked what is the reason. I requested all the advocates, because it won't be proper to invite one advocate. I asked the additional district judge, she was a madam, now she has been transferred. I asked everyone to my house, why partition suit 14 years? Now this happened in 2019, now 4 years have gone. Then the presiding officer very politely said, sir, 3 deaths had taken place. Even then, why immediately they have to file a LR petition, but that is not the practice, sir. Suppose somebody, now I conveyed this to members of the bar also in 1 or 2 places. The senior advocate won't come. He will depute his junior to go and inform. Even junior may be running here and there. So he may ask some advocate sitting in the court hall, he will touch when the case is called. So and so, first respondent died for steps. So the judge also, it is represented, the first respondent died, steps 3 months after, some date. Then it will go up to 1 or 2 years. That is what that presiding officer said. For these 3 deaths, nearly 6 or 7 years have gone. What I am saying, I am going to convey it to every bar. See, when even honorable judges can also mention this whenever occasion comes. When any council makes a representation, so and so died, at the same time, let them collect his or her LRs, put it in small paper, need not be petition like so and so, they are the legal heirs, male or female, age. If minor is there, then usual. So if the other side agrees, then immediately the presiding judge can record it and post it for next hearing for a trial. Unfortunately, that is not being followed. Now that suit the age of that suit is 17 years. No, every day I go morning walk up to that border. No, I feel what is the purpose in serving judiciary, rendering so many judgments? In practical, it is not happening. Now I am going to tell one more incident afterwards. So these cases have to be referred to mediation, Lok Adalat. Lok Adalat is taking place. I am very carefully watching what is happening in districts and high court. But advocates have to convince. See, little give and take. It is not a fighting for a contractual work or a promotion from government service. After all, among own brothers and sisters. That is one. Then, no, I am not going to mention 18 and CPC, all those things. We have to, during COVID-19 season, maybe very inconvenient, but at the same time, it made us to follow this, modern method like online, etc., etc. So, though I personally feel personal appearance in court is preferable, but some occasion we have to. Now Supreme Court, everything is being, from sitting here we can verify which case is going on. Sometimes argument is also being shown. So we have to, our lawyers have to thorough with the modern technology. Only for that I am mentioning. Now I realized when the Bombay bomb blast case was heard, myself and Justice Chauhan, both of us are unaware of computer or nothing. For CBI, Additional Solicitor General, I have forgotten his name. Even just every day he entered our court hall with a smiling face. He won't carry any paper book, etc. One day I asked, where is the paper book, etc.? Immediately he took his hand, small iPad. He opened it. He completed that case with a small iPad. So why I am mentioning, nowadays every lawyer has to learn all these things. Of course, we have, at that time we were not familiar with it. So that also is required in this time. Then, finally I am coming to family court cases. Now I am going to say in Tamil, I read it in newspaper. குடும்ப நல வழக்குகள், particularly divorce cases, ஒரு வருடத்தில் முடித்து தீர்ப்பு கூற வேண்டும் அல்லது my request is 1 year. When I meet next time our Chief Justice, I am going to mention, our honorable judges can also convey this to our Chief Justice, and circular can be issued to all family courts. First of all, vacancies have to be filled up. And they have to finish it up within 1 year. 1 year, either settled or pass this way or that way order. I received one message through my YouTube. Karnataka மாநிலத்தில் 7 வருடமாக ஒரு வழக்கு ஃபேமிலி கோர்ட்டின் நிலுவையிலேயே இருந்ததை உயர்நீதிமன்றத்தில் முறையிட்ட போது உயர்நீதிமன்றம் அந்த வழக்கை 3 மாதத்தில் முடிக்க உத்தரவிட்டது. விரைவாக முடிக்க எத்தனை பேர் உயர்நீதிமன்றத்திற்கு போக முடியும்? கோர்ட்டு போய் தான் டைரக்ஷன்னா எப்படி முடியுங்க? அதே மாதிரி இன்னொரு வழக்கில் இதுவும் இட் ஹாஸ் கம் இன் தமிழ் நியூஸ் பேப்பர். டெல்லி உயர்நீதிமன்றம் இதேபோல் உத்தரவு செய்துள்ளது. நீண்ட ஒத்திவைப்பு வேண்டாம் என்று அறிவுறுத்தியுள்ளார். திஸ் இஸ் இன் ரெஸ்பெக்ட் ஆஃப் ஃபேமிலி கோர்ட்ஸ். ஈவன் மெனி இன் மை ஏரியா மெனி ஃபேமிலி கோர்ட் மேட்டர்ஸ் ஆர் பெண்டிங் ஃபார் 3 to 4 years. They come to my house. No, I said, I am not a lawyer, I am a retired judge, don't come for anything. No, I can't say, I can't give any advice. Only thing, when occasion comes, I can convey. These family court matters are pending everywhere. Finally, a humble request to our brother and sister judges, administrative judges. They are in charge of 1 or 2 districts. My humble request, they have to visit that district every month, preferably on a Saturday. You are not going in by spending your pocket expense. If air ticket, air route is available, use it, or by train or by vehicle. So every monthly once, one Saturday you have to visit, and the bar president and secretary note down their grievances, then meet all the judicial officers in the presence of PDJ, CJM, family court judges, and note down there. See, you may not aware how many vacancies are there. I heard in my district, Erode, fortunately today Madam Sister Judge is not there. She came to my village. What is her name? Anita Sumand is not there. She said she is going to Delhi. As on date, 3 additional district courts are vacant. So they have to convey it to the Chief Justice whenever they visit, and they have to take steps. So then that is one. Then by meeting the bar members, judicial officers, they can convey certain directions, certain decisions. All of them may not aware. See, you people are conversant with the Supreme Court judgments and High Court judgment, not our municips and magistrates. So many decisions are there. As all of you have mentioned, I can also mention my own judgment for 1 or 2 years. How to register a FIR, there is a direction to all our police officers. Like these things can be discussed through these officers, and when they get a chance to visit Chennai, they can apprise the Chief Justice and rectify these mistakes. And I especially, with this I conclude, I especially thank the administrative judge and other honorable judges, officers of the registry, particularly Mr. Srinivasa Raghavan, President, and Mr. Selva Kumar, Secretary. Both are responsible for this assembly and opportunity for me to interact with you. Other officers of the MMBA. Finally, the entire credit goes to all the bar members, Madurai bench, for conducting this function in a good manner, a grand manner. Thank you. Vanakkam.
Thank you, Lordships, for sharing your rich court experience.
No duty is more urgent than that of rendering thanks. May I now request the General Secretary of MMBA, Advocate Mr. Airam K. Selvakumar, to propose vote of thanks.
It's given me an immense pleasure to offer the vote of thanks for the felicitation ceremony of Honorable former Chief Justice P. SATHASIVAM. My lords, when I was holding the post of law officer, my then colleague, Mr. Bhaskar Panin, Lordship Junior, he quite often would mention Lordships all sort of gracious things and other things. Now today I realized when the bar members met Lordships in the chamber and the guest bungalow, Chief Guest's bungalow, we really realized the Lordship's simplicity and other thing. Then I recollect the Tirukural, Paniyudayan Insulanadal, Oruvarku, Anigalan Machupura. Lordship may have rendered impeccable service during all the postings Lordship held. But apart from that, the simplicity of the Lordships, it's really a wholeheartedly appreciable thing by the everyone. என்ன ஒரு திறமை என்ன இருந்தாலும் அந்த பதவி இருக்கும் பொழுதும் மனிதனாக இருக்கும் பொழுதும் அந்த பணிவும் இன்சொல்லணும் அது மாதிரி ஒரு அணிகலன் வேறு எதுவுமே இல்லைன்னு வள்ளுவர் சொன்னது தான் லார்ட்ஷிப்பினுடைய எளிமையை பார்க்கும்போது தெரிஞ்சது. அது இப்போ ஒரு இயற்கை விவசாயம் பண்ணுறாங்க, அதை பற்றி பசுமை உடலாம் வந்திருந்தது. ஸோ லார்ட்ஷிப் இங்கே வந்திருந்ததுக்கு லார்ட்ஷிப்புக்கும் மிஸ்ஸஸ் லார்ட்ஷிப் சரஸ்வதி அம்மாவுக்கும் MMBA சார்பில் நெஞ்சார்ந்த நன்றியை தெரிவிச்சுக்கிறோம். இந்த நிகழ்ச்சி விஷயமாக அட்மின் ஜட்ஜியை பார்க்கும் பொழுது
Your Lordship was so particular about the arrangements we are going to make and everything. அப்போ எங்களுக்கு தெரிஞ்சது லார்ட்ஷிப் வந்து எவ்வளோ பாசம் வந்து ஒரு மரியாதை வந்து சீஃப் ஜஸ்டிஸ் மேலே வச்சுருக்காங்கிறது அட்மினிஸ்ட்ரேஷன் தெரிஞ்சது. ஸோ ஆன் பிகாஃப் ஆஃப் MMBA அவர் டெண்டர் அவர் சின்சியர் தேங்க்ஸ் டு தி அட்மின் சீஃப். அண்ட் எங்களுடைய அழைப்பை ஏற்று இங்கே வந்திருக்கக்கூடிய ஹிஸ் லார்ட்ஷிப் ஜஸ்டிஸ் RVJ, ஹிஸ் லார்ட்ஷிப் மிஸ்ஸஸ் ஸ்ரீமதி ஜே அண்ட் ஹிஸ் லார்ட்ஷிப் KKRJ and senior counsels TSR sir and Krishnavani ma'am, Meena Sundaram sir, W. Anandavalli ma'am, bar council member Thalai Muttarasu, எங்களுடைய ஃபார்மர் செக்ரட்டரி MMBA ஃபார்மர் செக்ரட்டரி மிஸ்டர் மகேந்திரன் சார் அண்ட் ரெஜிஸ்ட்ரி அண்ட் இந்த நிகழ்ச்சிகளுக்கு ஹோஸ்டாக இருந்த மிஸ்டர் எல்லாத்தையும் கோஆர்டினேட் பண்ண சண்முக செல்வம் சார், சீனியர் அட்வொகேட் நடராஜன் சார், all other members tender our sincere thanks to the every members who were present in the Friday evening. Thank you.